Welcome to Young Legal Minds. This is my last video on offer and acceptance, and in this video I will be covering acceptance. I've already covered offers, invitations to treat and revocation of an offer, and I will put all of the videos in the playlist on my channel so that you can access all of them at the click of a button. Firstly, you need to understand that the courts take an objective approach to the issue of acceptance, just like they do with offers. So they ask themselves, would the reasonable man construe this as an acceptance? Would this amount to an acceptance from an objective standpoint? So they take the same approach to acceptance as they do with offers. Thus, the conduct of the contracting party is what you need to look at. The conduct, what was said and what was done, more so than what they say they did, more so than what they say they intended to do. It's the conduct that's important, what they said and did, because the courts take an objective approach to acceptance, just like with offers. Now, the general principle in relation to acceptance is that it must be communicated, as shown in the case of Torres and Miles Far East. In other words, it must be brought to the attention of the offeror. So in the case of Torres, Lord Denning said, and I quote, "Suppose, for instance, that I shout an offer to a man across a river or a country yard, but did not hear his reply because it is drowned by an aircraft flying overhead. There is no contract at that moment. If he wishes to make that contract, he must wait until the aircraft is gone and then shout back his acceptance so that I can hear what he says. Not until I have him an answer am I bound." So the acceptance must be brought to the attention of the offeror, and this would be the same if you made an offer over the phone and the line went dead. In order for acceptance to be valid, one of the parties should ring back, and acceptance should then be restated by the offeree. However, there is an exception to this general principle, and that is known as the Postal Rule, which derives from the case of Adams and Lindsay, and provides that acceptance is effective as soon as it enters the postal system. So the moment a letter of acceptance is posted, it amounts to a valid acceptance. And the case of household fire insurance and grant shows that the Postal Rule can apply even if the letter of acceptance is never received. However, the case of London and Northern Banks shows that if the Postal Rule is to apply, then it must have been posted via Royal Mail, and therefore if it's handed to a private courier or anyone else, then the Postal Rule will not apply, which seems quite absurd when you compare this with modern business practice, which can often involve the delivery of messages through a private courier, and this has implications regarding modern methods of communication too. So things like email, inbox messages, voicemail and fax, pager. I don't know if anybody uses them anymore, but it's an example, as that is not itself carried out by the Royal Mail. As I said earlier, and Torres and Miles Far East shows that acceptance is generally effective once communicated. And in Torres, a modern method of communication was used to accept an offer, and the courts held that it will only become effective once the offeree receives it. So the Postal Rule does not apply to modern or instantaneous methods of communication. However, Brinkybon and Starhag Stahl does show that the courts do take into account sound business practice, which suggests that acceptance may become effective when it reasonably ought to have been read, so when the reasonable man would expect it to have been read. So if you accept an offer by email and it does go through to the offeror, and 3 working days or 3 days of office hours pass and they do not check their email, acceptance may be effective and the risk may lie with them. Now, going back to the Postal Rule, there are some requirements which must be met in order for it to apply. Firstly, it must be a reasonable method of acceptance, as shown in Henthorne and Fraser. In Henthorne and Fraser, the parties lived quite far apart, and so it was reasonable, as during the late 1800s, which is when this case occurred, communication wasn't as easy as it was today. So it must be reasonable. A question you should ask yourself, though, is when would it be unreasonable? Well, perhaps if you live right next door to the person whose offer you wish to accept, yet you put a letter of acceptance in a postbox to be sent to your neighbour, that would probably be unreasonable and probably quite daft. Or if you're aware that the likelihood of the letter reaching the offeror is very slim for whatever reason, that would likely be unreasonable. Or say if you know the offeror is moving house on Tuesday and you post a letter on Monday night, then that would be unreasonable. If it wasn't a reasonable method of acceptance, then the postal rule will not apply and the acceptance will be effective once it is received. You should also take into account that technology and communicative methods have advanced quite a lot since the late 1800s, which could lessen the likelihood of postal acceptance being reasonable in some circumstances, because if you remember what I said, the parties lived quite far apart, and in the late 1800s, communication, it was harder to communicate with each other. If it was reasonable, then the next thing you need to look at is whether or not the offeror displaced the postal rule, so excluded it as a method of acceptance. The rule is that an offeror can displace the postal rule, thus rendering it an invalid method of acceptance, as I said. And so in the case of Hodwell Securities, the offeror stated that he required notice in writing for the acceptance to be effective, and the fact that he used the word notice meant that he needed to receive the letter. He actually had to receive it in order for the acceptance to be effective, and so the postal rule did not apply. And this links into another issue. What if the offeror prescribed a method of acceptance? Well, if that's what the offeror did, then no other method can be used as a method of acceptance, as shown in the case of Eliasson and Henshaw. However, if there is no prescribed method of acceptance whatsoever, then the case of Tin and Hoffman shows that an equally expeditious or advantageous method will suffice. The letter of acceptance must also be properly posted, so if it's posted incorrectly, then the postal rule may not apply, as shown in Contemar's case. However, a new approach has been taken by the courts. Treatle, a professor of law, has suggested that if the letter is not properly posted, so if it's misaddressed, then it should become effective at the time least favourable to that party. Now, this is a well-respected view by the courts because the courts are keen to enforce agreements. Should the postal rule not apply and the letter never be received, then acceptance will never be valid and the contract cannot be enforced. However, if it is not received because it is misaddressed, then the courts can still enforce that agreement, and this is why they like this approach. And it was taken in the case of Corbitus or Corbitus, however you want to say it. You need to understand that Contemar's case does not form a general principle, and so the courts may take the latter approach. The logic behind Treatle's argument is that if a letter is not properly posted, by the time the offeror does receive it, acceptance may benefit the offeree. If, for example, the market price falls before the offeror received the acceptance, but after it was sent. And Treatle argues this should be prevented from happening, and so it should become effective at the time least favourable to the party that sent the letter. And the final question is, would the application of the postal rule lead to absurdity? If so, it will not apply, as shown in the case of Hodwell, where the judge referred to the obiter in British and American Telegraph Co., which suggested that a stockbroker would not be liable in damages because he didn't sell it in a failing market in accordance with the instructions contained in the letter which was posted but never received by him. So that's the postal rule and its exceptions, which can seem quite lengthy and complex, but it is really simple once you get to grips with it. Moving on, there are other principles relating to acceptance that you must be aware of. One of those is silence. So what about silence? Can that ever amount to acceptance? In Felthouse and Bindley, a man wanted to buy a horse and he used the words, "If I hear no more, I consider the horse mine." And the court held that silence cannot amount to acceptance. He had no right to impose that offer on somebody. There is, however, an exception to this, and that is unilateral contracts, which can be accepted through performance. This would involve things like reward cases, so lost dog posters and things like that. In Brogden, the defendant drafted a contract to the claimant. The claimant made some changes to the contract and sent it back to the defendant. who then never communicated acceptance but embarked upon performance of the contract, and that amounted to a valid acceptance. So Brogdon shows that performance can amount to acceptance, and this is the exception to the general principle on silence and acceptance. In my video presentation on offers and revocation of an offer, I briefly spoke about counteroffers. Now, if you remember, with counteroffers, I said that they destroy the original offer, as shown in Hyde and Wrench. If you want the facts, you can get them from the video on revocation. They are there, and it's pretty simple to understand. This is just to link it into acceptance. Now, because the counteroffer will destroy the original offer, that means the original offer will be incapable of being accepted. And this applies to cross offers too, as shown in the case of Pickford, which I also went over on my video on revocation of an offer. However, a request for information does not destroy the original offer, as that does not amount to a counteroffer. And so in Stevenson and McLean, the defendants offered to sell some steel to the claimants, who then asked if they'd deliver the steel for 2 months for 40 shillings or something like that, or if not, then how long they would deliver for, which was merely a request for information, not a counteroffer. And you must understand the difference between a request for information and a counteroffer, as sometimes they can seem quite similar, but they are entirely different. There are situations where companies enter into what's known as a battle of forms. So one company wants to do business using their standard terms, and the other company wants to do business using their standard terms. Well, in that situation, which terms would prevail? Well, the case of BRS and Arthur Crutchley establishes what's referred to as the last shot principle, which essentially provides that the terms last introduced will prevail. And this can be further illustrated in the case of Butler Machine Tool, in which claimants wanted to do business in accordance with their standard terms, and the defendants wanted to do business in accordance with their standard terms. The plaintiffs filled out and signed the defendant's form, and so it was the defendant's form which last prevailed. I also said in my video on revocation of an offer that statements of minimum price are not offers, as shown in Harvey and Facey, so they too are incapable of being accepted. And that is my entire series on offer and acceptance completed.